Hi, it's Scott Oswald, Chair of the Qui Tam section of the Federal Bar Association, and we are here today with Traci Buschner. Traci is a partner at Guttman, Buschner Brooks in the district, and she is moderating a panel at this year's annual conference on February 28th and on March 1st on ethics in Qui Tam matters. And Traci, give us just a sense of maybe both our panelists and maybe a little something that we can expect. If I'm in the audience and I'm attending the panel, what I can expect to see.
Thanks, Scott. I'm really happy to be chairing the ethics panel this year. Last year I was on a panel about settlements and Qui Tam settlements with some other lawyers, and we had a really good time, so I'm really excied this year about handling the ethics part of it. The panelists that we have set up are some really fascinating people that have a lot of experience, so I think it'll bring a broad knowledge base to the panel, and hopefully we will be able to interact, and that's what we're planning for our panel, is to have an interactive discussion about ethics. Some of the panelists that we have are David Wiseman, who is a senior a person in the DOJ's commercial litigation department. He actually has a very interesting job at DOJ, which is he's an ethics responsibility or professional responsibility officer within DOJ, and so he has brought some of the more sticky problems, I guess, that DOJ has to deal with, and so he has to help the lawyers over there navigate those problems. And then we have Precious Gittens, who's at Hooper, Lundy, and Bookman. She's a defense lawyer, but a longtime U.S. attorney in the District of Columbia. Has a fabulous background doing white-collar criminal defense, and I think she'll be, give us a lot of information about the inside of Qui Tam cases, especially where there's a criminal parallel investigation. And then we have Kathleen Clark, who's at the Washington University Law School in St. Louis, whose area is professional responsibility, but she also has a very rich background as well. Served on, I think, the Senate Judiciary Committee, has been a former law clerk, and has written pretty extensively in the whistleblower area, especially on ethics. So that's our panel. And so what we had decided to do is to do sort of a short fact pattern, which will present problems for the relator, the defense, and for the government. And we will question the audience and get their feedback as to how these problems can be resolved. So we're looking forward to it, and we think it might be kind of fun.
So if I'm in the audience...
As fun as ethics can be.
So if I'm in the audience, I can expect to play a role.
Yeah, we're thinking that it will involve either some sort of way that you can, I think it's an electronic system we're going to try to use, where you can cast your vote for an A, B, or C answer, and then we will discuss those.
So I know one of the topics that Relators Council deal with all the time, that's an ethics issue, is cases that are under seal.
Right.
And so we have our case under seal, and maybe there's an inquiry of some sort, maybe there's another filing we want to make with a different agency. How do we deal with that from an ethics standpoint? Right.
So the statute itself requires the relator to seal the case when it is filed. And although the federal statute requires sealing for 60 days, they often become sealed for much longer, as we know, because the government needs more time to investigate. So during that time, the relator sometimes can get more information. They can decide, perhaps, or he or she could decide that maybe another government entity might be involved, a state or local government. Sometimes the information is the subject of a congressional inquiry. Would the judge consider a disclosure to that agency or to Congress to be a violation? I think you always have to think about that, even if the likelihood of the information being disclosed to, say, the press or to third parties or to the public at large might be very small. I mean, you're the one that will be disclosing this information and will be on the hook if something happens. I think one of the ways that you can solve solve that issue is to go to the government and seek their guidance. We have done so in the past, and normally the U.S. Department of Justice will have some way to solve that problem, whereby you will be covered and your client will be covered.
And I'm hearing from you to do that before.
Yes.
Before the fact.
Before you think about, yes, disclosing it, and always think, even I think you have to be super careful. So even if it's like a new state or a new whatever, I think you have to go through that thought process of, what does the seal say? What are the particular words? At least letting the government know. I think if the government has a problem with it, they're the real party in interest. And if you have to go to the judge, then you want the DOJ, I think, on your side, saying, yes, we knew this was going to occur. Yes, we agreed with this, or yes, we took these particular precautions so that the information wouldn't become, unsealed or known to others that are not supposed to know the information. So,
Traci, thank you.
You're welcome.
And we want to invite all of you to this year's Qui Tam conference. It is on February 28th and March 1st of 2019. We look forward to seeing you there.